Estate planning is a critical component for SMSF trustees looking to protect their wealth upon death and also in their later years. I have Grant Abbott, Principal of Now Infinity, joining me today to discuss a few estate planning issues. Welcome, Grant.
Hi, Darren. How are you?
Very well, thanks.
That's good.
Look, why is estate planning so important for SMSFs?
Estate planning, probably, if I go, well, I've been in the industry right from the start since 19 years, and probably in the first 6 or 7, although I used to talk about it a bit, it was really not a big issue because most member balances were 100,000 or 150. So, you know, that you can't really go through the expense of affording estate planning when you're worrying about that. But now the average size self-managed super fund is around $1 million and going up, where member balances are on average $500,000, and you have to look at it. We've got small funds, so it means there's a lot of people with, 750 plus sitting inside their fund. Once you look at that, you need to focus in on estate planning and understanding and giving the trustees an understanding of what's involved in estate planning. I've been doing quite a few seminars for some of our Now Infinity advisors to their trustees, and I find it really hits home because everyone says that they don't want to rule from the grave, but if you ask them the question, well, what happens if you both died yesterday? Suddenly it's like, oh my God, what am I going to do about the daughter-in-law or the son-in-law or the children, and can I protect my bloodline? And I've seen that with my parents, is that as they get older, this friend drops off or this auntie drops off and all of that sort of stuff, and it really starts to bring into focus as to what should happen, because it's a very emotional issue, but it's a crucial issue, and it's also a great opportunity for any advisor, any professional advisor, to move into that estate planning space.
Now, in the SMSF world, it's not enough just to allow your retirement savings to revert back to the greater estate of the family, is it?
No, look, I think this is where it's very careful. There's two areas in terms of the RG146, or the set of competencies to become an SMSF advisor, which obviously we've got quite a few now. Accountants are going to have to meet those competency standards in the next few years anyway. The two standards are, first off, that it's a requirement for advisors, when they provide advice, to understand estate planning. And estate planning, the root tool of it comes out of the deed. And I could talk forever on Katz and Grossman and Donovan and also the tax office rulings around estate planning, but the deed is essential. Whatever goes in the deed, that's the driver of it. So an SMSF advisor needs to understand what's in the deed and what can be done from there. The second element is that the advisor also needs to make sure that when they outsource to someone, that person is also competent. And what's happened and what's transpired over the last 10 or 15 years that I've found is that advisors, and I think they tend to probably get scared of doing that, even though that's part of their competence, or supposed to be part of their competency set, they give it to a lawyer. And then generally the lawyers aren't really in tune with SMSFs, and they tend to say, well, there's a big area of law there, I know there's 2,800 pages, let's just shift it all to the estate. And so when it goes to the estate, then it becomes open to challenge, and that's the typical thing, because the lawyer's not aware that SMSFs are governed by federal law, and there's a lot of things that you can do in them. So when you have a look at that, I think it's really important for advisors to get involved in that estate planning process, but also be very mindful of who they're outsourcing to. I mean, a funny story happened to me, years ago, I think in 2001, Peter Bobbin drafted up a whole lot of testamentary trusts for me, which was good, but they were really thick. And it took me ages for me to read and understand. But they were right at the time, and it was funny because about 3 or 4 years ago, Shane Ellis came to me and said, well, let's update all those sort of things, and let's update the testamentary trusts and all that. And again, he gave me a whole lot of testamentary trusts, and he gave me a discounted package that I think I ended up paying $7,000. But my wife and I, Amrita and I, sat down one night and worked out, because typically for a lot of clients, particularly if they're with accountants or whatever, they've structured themselves much the same as me, where you've got a family trust, which is outside the estate planning. You've got your self-managed super fund where you've got a lot of assets, which is covered by an SMSF Will. And I had a couple of properties at that stage which were jointly held by myself and Amrita, so that if I died, my family trust is looked after, my self-managed super funds looked after, all my properties go to Amrita. So I paid $7,000 for these testamentary trusts, and effectively they were only over my, and all my cars were leased, only over my golf clubs, my clothes. So my kids are going to have these clothes that are stuck in this expensive testamentary trust. And so I think that really what we need to do, or what I see happening, and I've had a chat with Dan Butler about this, is that I think prices are coming down, but also they're getting a lot more simplified. The days of charging, $10,000, $15,000 for estate planning is really well and truly over, particularly if at the end of the day, all the lawyer's giving you is a precedent that they've bought off someone else and just packaging up. They might have even read themselves. Just said simply, this is a one-size-fits-all. If you want one-size-fits-all, I suggest you probably go to a retail or industry fund.
So in terms of that, you just talked about testamentary trusts. What are some of the tools and methods that people can use to effectively put together an estate plan?
Well, there's stuff outside, as I said, like the family trust. Again, the assets you've got in a family trust, and it's incumbent upon everyone who's doing SMSF advice to understand all the estate planning ramifications. Now, it doesn't mean you're actually going to do that, because that would probably breach the Legal Professions Act, but you have to understand the family trust has its own unique methodology of distributing assets and just continues on until it's actually wound up after 80 years. That's all embedded into the deed. When we come down to outside our estate, we can obviously pass things over to children, anyone in the estate. Alternatively, if we're concerned about our children or we want to pass a particular asset down bloodline, we may set up a trust, which a testamentary trust means it just springs up out of the will. And inside that, you have a whole lot of terms and conditions. You might have someone who's getting an income stream, but they don't have any access to the capital. So you have an income beneficiary versus a capital beneficiary. And that works pretty well if you've got a blended marriage. You might have the spouse, second spouse or third spouse getting the income, then children from the first marriage, getting the corpus when the other one dies. But then we move straight to the self-managed super fund and our tools. There's quite a few tools, but the basic one is what we call it in the accumulation stage is your binding death benefit nomination, which is, people have to understand the limitations around that. And again, this has got nothing to do with the law, because the law doesn't apply to self-managed. It's what's in the deed. But the basic there is a binding death benefit nomination just generally talks about percentages. So it should go 100% to my wife, and then if she's not alive at my death, it goes certain percentages to children, which is A-OK. So that's normally the case. But if you want to do things like this bit's to go, a pension to go to my wife, or this asset is to go to my child, particularly if you're dealing with farmers who've got their farms in and they want to transfer the asset to a child who works on the farm, then effectively when you're doing that, you need to set a whole set of binding directions. And so it's just like a BDBN on a bit of steroids. So you just draft that up, and effectively once that's drafted up, it's just a set of binding death benefit directions. A lot of people call it death benefit rule. I started the name years ago, SMSF Will, mainly just because it's to tell a client, well, I'm doing a non-lapsing set of binding death benefit directions to become a death benefit rule. It's like, as soon as you do that, you've lost the client, because clients need to do anything, clients need to be absolutely confident that they're comfortable with what you're doing. You want them to walk out secure and comfortable. So we just call it a SMSF Will, but really it's just a set of non-lapsing binding directions. So, it's just an easy sleight of hand. On the other side, when you get to pensions, if you have a typical, which most people do, they have a TRIS or an account-based pension, and that's it. When they die, that pension itself, you have to go back to the deed, but generally that will be covered by a BDBN or be covered by SMSF Will, because effectively it does go back to the accumulation stage. And you've got to be very careful, and just make a word of warning for a lot of people that the commissioners or the rules about extending that segregated or exempt pension stuff is really good, provided your deed allows it, because if membership ceases at the time of death, then that rule doesn't apply anyway, because that member's balance is cut off and ends up back at the accumulation. But that's, again, the trustees are important. But probably the better one is, and I coined a term years ago for it, which really flows on from most defined benefit funds or government funds, is that someone dies, it then passes on or transfers to a next person. So it's a continuing pension, but what happens is the account actually moves over to someone else, and that's generally what's required. So an auto-reversionary pension is what we call it. It's a continuing pension, and then it's like pass the parcel. So dad gets it, mum gets it. If mum's alive, if mum's not alive, then it goes to the next person. If they're not alive, then that's when you pass it out to the estate. And obviously, if you've got an auto-reversionary, it may be the instance that you can't pay, under the current rules, you can't pay to a child who's over age 25. So that may be the place that you then pass it to the estate and put it into a testamentary trust for protection. So all of them work really well together, but you've got to be really on top of it.
Yep. So as a good estate plan, does that cover things like incapacity in later years and maybe the aged care issue?
I think that's a really good issue that you raise, and we've put it into the deed, and I've done a couple recently and tested it out on my parents, and maybe we should do it with your parents as well. But there's a good opportunity now that there's 300,000 people in Australia with dementia. If you listen to Ida Buttrose and General Peter Cosgrove, I mean, they're out there really talking quite heavily about it, that dementia will now affect 1 million Australians by 2030. I think it's all the baby boomers, and the issue raises important aged care, and I know you've got the Aged Care Summit coming up in November, which is really important, and I'm going to be speaking at that because I am quite passionate about it. But estate planning focuses more on what happens on death. So what we need to do is, in order to look after the needs of the infirm, so the ones who lose their mental capacity, it's probably going to be, if you have a look at it at some point in time, it's probably going to be either you or me will lose it at some time, or probably both of us together. So that you need to put in place a plan for incapacity. What happens when someone's mentally incapacitated? The enduring power of attorney needs to be appointed. Is that an automatic appointment? And all this comes from the deed. And then I've put into the SMSF Strategies Now Infinity deed, I've put in place what we call a living will, which is, again, it's a set, the same as the estate planning, it's a set of binding directions to be given to the trustee as to what is to happen in the event that the member becomes mentally infirm or mentally incapacitated. So it could be that they are, I think I did with Mum, is that the ongoing trustees must provide for a reasonable standard of living. Because I've seen in too many cases in estates and individuals where Mum's infirm or Dad's infirm, so let's just push him off to a nursing home. He doesn't know, but you don't know whether they don't know you. They need to have a reasonable standard. But what we'll do is we'll keep the capital, because when they pass away, we'll enjoy the capital. Scary thing is, if you've got clients out there, you have to tell them that once you've got dementia or Alzheimer's, you tend to have no worries in the world, and life expectancy is up around about 10 years. So they need to have, you actually need, if you've got dementia or infirmity, you need to have a reasonable size capital base in order to cover you through those future years. And with the aged care summit, things I'll be talking about is warehousing an aged care place, or because you can now buy them freehold, and I'll see that in the future, freehold with a whole lot of amenities around the full service amenities that you may or may not use at any point in time. But putting that in your self-managed super fund now, so that when the time comes, you lease it back to the church or whoever's doing it, but when the time comes, you've got access to that, and you just simply transfer it out of the super fund. Or the better way to do it is, if, for example, this happened with Mum and Dad, Dad's 81, can't make any contributions, but they sell up this property, and then they buy the aged care property out. So you're actually taking one asset out and replenishing it with cash, which then covers all the necessities. So I think that's also an exciting area for all SMSF advisors to get into. And again, it's incumbent upon, it's part of our competency standards. You need to do these things. You can't put your head in the sand. You need to actually look after this for your clients.
Okay, well, I can't wait to hear that presentation at the Aged Care Summit, but apart from that, thanks for your time today, Grant.
Okay, thanks for that, Darren.